కెమెరాకి ఎలా పెడతాడు మర్చిపోయి ఇది మాట చెప్పాను ఫోటోగ్రాఫ్ బాగా ఇంట్రెస్ట్ ఉంది కాబట్టి నేను సీరియస్గా ఉంటాను నిజంగా దాన్ని పెట్టుకుంటాను. బ్యాటరీ speech yes they not using whether we any
all the students please be seated. Maintain high silence. Organizers be there. Yes, you can start.
A very good afternoon to the respected honorable bench. This is speaker number 1 of team code 103. And this is speaker number 2, and this is researcher. So today I'll be dealing with all the facts in issue number 1 and 2 on behalf of the petitioner, and my co-counsel will be dealing with issue number 3 and 4 and prayer. The counsel is seeking permission to proceed with the jurisdiction of the case. Much obliged, Your Lordship. The petitioner humbly submits this memorandum before the Honorable Supreme Court of Bharatavarsha under Article 137 of the Constitution of Bharatavarsha. The council is seeking permission to proceed with the facts of the case. Much obliged, Your Lordship. The Sabarimala temple of Lord Sastavu is located in a beautiful state of Kerala. It is the most populous pilgrimage temple in Bharatavarsha. Around 40 lakhs of pilgrims visit this temple every year. The Sabarimala temple is one of the few temples of Bharatavarsha that allows both men and women to pray to Lord Sastavu, irrespective of their caste and religion. Based on the historical background of the Hindu mythology, Lord Sastavu is a child of Lord Vishnu and Lord Shiva, and Lord Vishnu who is reincarnated as Mohini. From the commencement of his birth, Lord Sastavu has always known his purpose of his life, that to answer his prayers, to all his prayers of his devotees from the place of Sabarimala by taking a permanent celibacy, which is also known as Naistika Brahmacharya. Although the temple follows strict customs and rituals, it allows women to pray to Lord Sastavu, but they are restricted to enter into the inner sanctum of the place. This tradition has been followed for over 600 years. However, the temple authorities disallow girls and women of the age 10 to 50 into the temple sanctum. The reason behind this is the menstruating phase of the women should not enter into the temple sanctum because that would affect the celibacy nature of the Lord's Sastav. And yes, it is not discriminatory on the restriction of the entry of women into the temple sanctum because of the celibacy nature of the Lord's Sastav, and a person who is being a permanent celibate, also known as a Naistika Brahmachari, should not come into a contact with women who is capable of reproduction. And also, since the temple has a religious denominational character, it has a right to apply its own rules and regulations to the temple. In the review petition that follows, it is explained that this cannot be considered as discrimination on the basis of sex. There are customs and rituals that have been followed since time immemorial, and it is not anti-Hindu nor unconstitutional. Further, being a religious denomination, this temple has authority to lay down the guidelines of the temple. Under such circumstances, the petitioner seek a direction from the Supreme Court to uphold the religious sanctity of the temple and honor the distinctive celibate nature of the Lord Ayyappa. The council is seeking permission to proceed with the issue number 1. Much obliged, Your Lordship. Whether the restriction of entry of women into the temple sanctum violates Article 14 of Right to Equality and discrimination of Article 50 and abolition of unsuitability of Article 17. The Council is seeking permission to proceed with the advanced arguments of issue number 1. Much obliged, Your Lordship. Your Lordship, Article 14, which is referred as right to equality, is indeed not violated on the restriction of entry of women into the temple sanctuary. Because Article 14 has been laid on the principle of equals should be treated equally. And also, Article 14 is not absolute. It is subjected to certain restrictions on the doctrine of reasonable classification. Under this doctrine of reasonable classification, which is based on the intelligible differentia, the differentiation can be made on the valid reasons, and such differentiation would not infringe Article 14. For example, there are government officials and as well as common individuals. These both classes cannot be considered as one because the government officials obviously has an exemption from the liability of criminal side as well as the civil side, while on the common individual side, they cannot be exempted from any kind of liabilities by both criminal as well as civil. So here, a common man cannot come and contend that his right to equality has been violated for not getting the exemption from the liability where the other government officials have been getting the exemption. So in the same way, and also there are many temples in the Bharatavarsha where men doesn't have an entry to the temple itself. For example, there is Article Bhagavati temple in which during the Article Pongal festival only the allowance of women is permitted and not the allowance of men. And also there is the Mahabala Sundari temple in Rajasthan in that the whole temple is subjected to in the mind of the women, and no men cannot be entered into the temple throughout the year. And also there is a temple called as Kanyakumari Bhagavati temple. In this temple, to the inner sanctum of the temple, only women tend to be allowed and not the men. So these are all the temples, and there are not only these, there are many other temples where the men also doesn't have any right to enter. So in this scenario, why a man cannot and didn't come and contend that his right to equality has been infringed? Because there is no infringement of equality at all. It is not it doesn't come under an equality, it's just a tradition and customs of a Hindu religion. And coming to the Article 15, the restriction of entry of women into the temple sanctum would not violate Article 15 because this cannot be taken as a discrimination itself, Your Honor. In fact, if we wanted to see in that point of view, if the temple authority put down a guidelines of women of any age shouldn't be allowed into the temple, then it would be contended to Article 15, then it would lead to the violation of Article 15. Since in this scenario, the temple authority has put on a temporary restriction, not a permanent restriction of the whole gender of women, Your Lordship. There is a limited restriction from the age of 10 to 15 and not on the whole age. Hence, it doesn't contend to the violation of Article 15. And also, Your Lordship, many critics have been telling that Lord Sastavu is a god of discrimination. In that scenario, if the Lord Sastavu is really a god of discrimination, then why in the other temples, why there is a whole elements of women, irrespective of their age, are being allowed into the temples? For example, in Kerala, there are 5 temples, which each temple represents as a single form of the Lord Sastavu. For example, there is a Kurandapura Balasasta temple, in that he will be appearing as a kid. And also there is a Achankovil Dharmasasta temple, in that he will be appearing as a married man. And there is Adityavu Sasta temple, in that he will be appearing as a young man. And there is a Pandanam Ayyappan temple, and finally there is a Sabarimala Ayyappan temple. In Sabarimala Ayyappan temple, he will be appearing as a permanent celibate, not a temporary but a permanent celibate. He took a vow to himself that he should be stayed away from menstruating women to answer all the prayers of his devotees, Your Lordship. If Lord Sastavu has been restricted the menstruating women into any of his temples, then it would be contended as discrimination. And since here only in the Sabarimala temple there is a restriction, and out of the remaining temples there is no such restriction, Your Lordship, since it cannot be considered as a discrimination. And also, will a woman be discriminated if she doesn't enter into a men's washroom? No, because it is a privacy. It is on the policy of privacy. In the same way, the Lord Sastavu went and sat there for the sake of privacy, which is needed to be respected and not be violated, Your Lordship. And also coming to the untouchability, this definitely doesn't violate the Article 17, Your Lordship. Because this restriction of a particular age of women has been so misinterpreted as impure and as untouchability, which is so amiss. In fact, in Hindu tradition and Hindu religion, they really treat menstruating women as a goddess. For example, there is a temple called Kamakya temple in Guwahati, where literally they will worship the menstruational cycle of the goddess. And also there is a Mata temple in Bihar, where in certain regions they will be allowed only for the menstruating women, and no other women nor men can be entered into that particular period of time into the temple of Mata temple. If they are being treated, if really they thought that menstruating women are impure and unconstitutional, why they will be praying the menstruation cycle of women, Your Lordship? And also here, I would like to put up a point, Your Lordship. The temple doesn't belong to us. It is the place of the God, and it is the house of the God. We have to respect the terms and conditions of the temple, and we should not contend the terms and conditions of the temple. This is the same position even under the law. If I wanted to go into somebody else's houses, I wanted to go based on their terms and conditions, based on their timings, based on their convenience. And if I violate the terms and conditions of the other person's house, then it will amount to trespassing, Your Lordship. In the same scenario, the temple is not ours, Your Lordship. It is the house of the God, and we have to respect his terms and conditions, because even the God is an unnatural person, and he also has the right, and which we do not have the right to contend or violate, Your Lordship. The council is seeking permission to proceed with issue number 2, Your Lordship. Much obliged. basis of public worship rules permit a religious denomination to ban the entry of women between the age of 10 to 50. The council is seeking permission to proceed with the advanced documents of issue number 1. Much obliged, Your Lordship. To commence with, the Sabarimala temple is indeed comes under the religious denomination of Article 26 because it satisfies all the conditions which was put up by the Supreme Court, such as it is a collection of individuals who have a system of same beliefs and they have been praying to the same God. And it is designated by a distinctive name and it has a specific customs. In order to enter into the temple, they have specific customs since it fulfills a complete religious denominational character. And also in general, Sabarimala specifically is classified to the Hindu religion, thus classified to be a complete religious denomination. And therefore, if an institute has having a religious denominational character, it can put up any rules and regulations of their choice, of the temple authority choice. And also Justice Indu Malhotra, in her dissenting opinion, has stated that Sabarimala temple satisfies the requirements of being a religious denomination and therefore could avoid the protections under Article 26. And on the entry of, since the entry of menstruating women, restriction of entry of menstruating women is limited, it would not be violation of Part 3 of Indian Constitution. And the restriction of menstruating women has been upheld in the case of S. Mahindran versus the Secretary Chakra Devaswam Moot, which says that prohibition is only under the respect of a particular age, not as a class. So here there is no inequality based on the class, but only on the particular age of the class. Since it would not amount to even Article 14 and also other parts of the Constitution, Your Lordship. And also, Your Lordship, the restriction is not solely based on the menstruating factor, Your Lordship. There are many other factors above from the menstruating factor reason, such as under the yogic science, there are 5 pranas, which is known as pancha pranas. There is prana, apana, samana, udhana, vyana. In these 5, the prana energy always flows in the upward direction, while the apana energy always flows in the downward direction. Since it has been proven that all the temples have had a much prana in their surroundings, and while the menstruating woman has so much apana in her, since disrupting the energies between them and make discomfort and health conditions to the menstruating woman. And also, it has been proved that Sabarimala temple is a Tantric temple, which is based on the spirituality of humans, therefore regulates their energy. Like I said before, since this Sabarimala temple is constructed on a tantric basis, it has the potential to regulate the energy of the human beings, mainly the menstruating women, hence makes some sort of discomfort in their body if she enters into the temple premises. So, the menstruation cycle is not the only sole reason. These are the other reasons on why they put a limited restriction on the age of the women. And also, under law, if you wanted to put up a perspective under a law, there is Section 13 of Indian Evidence Act. If it is under Bharatiya Saksha Bill, it would be a Section 11 of Bharatiya Saksha Bill. In this, they have been contend that if a customary right has been practicing for a long term of year, then it would be made as a customary right. And such customary right cannot be questioned. This has been told in the Section 3 of the Indian Evidence Act. And also, under Section 48 of the Indian Evidence Act, opinion as to existence of right or custom when relevant. Under this section, if court has to form an opinion under the existence of the customary right, they can be appointed for expert opinions. On the expert opinion, if that such customary right can be marked as relevant. And from the beginning, from so many days, many of the respondents to this site have been contending that there is no written instrument on this particular restriction. They've been contending that while there is no written instrument on the restriction, then why should it be a maintainable fact? Since your lordship, the unknown truth is there is a written instrument which was mentioned in Tantric text, chapter 10 and verse 11. In this, they have said that menstruating women cannot be come inside the temple shrine as it would affect their health and the energies of the temple as well as the deity. And this text is indeed maintainable, your lordship. And there is a sloka I would like to be mentioned that Ishvaro idam sarvam yakkinchi jayatyam jagattena tyatona bhujigam ma bhugaha kasya vidhanamaha. This says that indeed all this is divine. This world is full of divinity and divine energy. Whatever moves in this moving world belongs to the God. We have to enjoy it, not question it or possess it. That's all, your lordship. I'd like to hand over my mic to the speaker number 2. Much obliged.
This is Speaker 2 from 103 on behalf of petitioner, your lordship. Council seeking permission to go with the issue number 3, your lordship. Much obliged. Is women's exclusion an essential religious practice under Article 25? Council seeking permission to go with the advance arguments, your lordship. Much obliged. The exclusion of women from religious places like temples on the basis of age or gender has been a continuous issue in India. In the legal context, the question of whether such exclusion constitutes essential religious practices under Article 25 of the Indian Constitution depends on various factors, including the interpretation of religious scriptures, historical practices, and the societal context. The judgments provided, the Supreme Court has emphasized the need to evaluate whether a particular practice is essential or integral part of a religion to determine its protection under Article 25. In the context of Sabarimala temple case and other similar cases, the court has examined whether the exclusion of women falls within the realm of essential religious practices. The judgment suggests that practices that are discriminatory based solely on gender or age and do not have a clear basis in essential religious tenets may not be considered as protected under Article 25. But therefore, in the specific cases of women's exclusion from religious places, it would be essential to analyze the historical, religious, and social significance of such practices to determine whether they qualify as essential religious practices under Article 25 of the Indian Constitution. If we see first case, Kantara Rajiv Arun petitioners versus Indian Young Lawyers Association, its General Secretariat and others, the judgment discusses the concept of essential religious practices and the rights of religious groups to manage their own affairs in matters of religion, your lordship. Not only in Bharatavarsha, even in Japan, the disappearance of women are like a Mount Athens, Greece, and Mount Oman is stopped women, your lordship, because which is situated more than 6,000 feet, where only males are allowed and females are strictly banned from attending. This is because high altitude of mountains, which will impact the woman's reproductive health, your lordship. Council seeking permission to go with the issue B, your lordship. Much obliged, your lordship. Whether Article 19, Clause 1, Subclause D is violated due to the restriction of entry of menstruating women. Council seeking permission to go with the advance arguments, your lordship. Much obliged. For the answer, we need to go back the legend. According to the Puranas, Chakra was born to a destroyed female demon who, thanks to a boon, could only be vanquished by a child born of both Shiva and Vishnu. When Chakra fulfills his destiny by killing her, a beautiful woman emerges from the water. She had been cursed to live as a demon, but her killing reversed the curse. Now free, she asks Chakra to marry her. He refuses, explaining to her that his mission is to go to Sabarimala, where he would answer the prayers of his devotees. However, he assures her he will marry her when Ganesh Swami stops coming to Sabarimala. Shaun now sits and waits for him at a neighboring shrine near the main temple and is worshipped as a Malika Kurtama. With hundreds of thousands of new devotees pouring in every year, hearts will be a long way. And that's why women do not go to Sabarimala. And if we see Article 19, Clause 1, Subclause D is contained with the provision freedom to move throughout the territory of India. So, as we know, more than the rule, exception plays more important role. Because if everyone gets only freedom, then they may misuse it. So the exceptions also given in the Constitution. Council seeking permission to go with the issue number 4, Your Lordship. Much obliged, Your Lordship. Whether the Sabarimala temple has denominational character, Council seeking permission to go with the advanced documents, Your Lordship. Much obliged. It is humbly submitted that several Supreme Court judgments have laid down to test to qualify as the religious denominations under Article 26. For example, the Constitution bench in S.P. Mittal versus Union of India, this court upheld the Constitution validity of the above. The word religious denominations in Article 26 of the Constitution must take care from the word religion, and if proves be so, the expression religious denomination must also satisfy 3 conditions. It must be a collection of individuals who have a system of beliefs or doctrines which they regard as a conducive to their spiritual well-being, that is a common faith. And second one is common organization, and third one is designation by a distinctive name. So, the Sabarimala temple is satisfied all these characteristics, Your Lordship. The right to manage the religious affairs cannot be abridged by any law, Your Lordship. These principles were established in the Right Panchanath Gandhi versus State of Bombay, Your Lordship. A temple, even if it is a public place of worship, do not lose its status as a abode of deity, which is the very significance behind the act of conservation or prana pratishtha. Council seeking permission to go with the issue number 4B, Your Lordship. Much obliged, Your Lordship. Does the temple fall under the definition of a religious institution belonging to a religious denomination within the meaning of Article 26? Council seeking permission to go with the advance arguments, Your Lordship. It is humbly submitted that the Constitution does not itself define a religious denomination, and therein lies the wisdom of the makers of the Constitution. The absence of the definition itself is an indication that the Constitution makers describe a rigid, fixed and mechanical approach to the concept and definition of a religious denomination. This is because, in their wisdom, there were aware of the limitations in prescribing the boundary conditions or conduct of what constitutes a religious denomination for all time to come. Given this country immense appetite for innovation and ingenuity in religion and spirituality. Therefore, the Sabarimala temple is the denominational temple under Article 26 and enjoys rights under Article 26. Had this not been the case, it is possible to kill the very idea of a religious denomination by taking a psychological approach, and that all paths lead to the same divinity. However, such an approach would defeat the constitutional mandate of Article 26, which is to protect the distinct nature of each path. Council is seeking permission to go with the prayer, Your Lordship. It is most humbly prayed before the Honorable Court that it should be considered that Sabarimala Temple is not violated Article 14, Article 15 and Article 17. The rules of Kerala Hindu Worship Act 1965 is constitutionally valid and it not violated Article 19, Article 25 because the deity Lord Sastha is a Naistika Brahmachari which means a permanent celibate. Pass other order that deems fit in the interest of justice and good conscience. And review petition is maintainable under Article 137, Your Lordship. Much obliged.
The council seeks permission to oppose the acts. Much obliged. The council seeks permission to address the bench as Your Lordships. Much obliged, Your Lordship. The council is here to represent the case of Travancore Temple Board versus Bharat World Employees Association on behalf of the respondent along with the co-counsel and researcher. With the new permission of the bench, the council seeks permission to move forward with the statement of jurisdiction of the case. Your Lordships, the review petition filed under Article 137 of the Indian Constitution is not maintainable. With the due permission of the bench, the council would seek permission to move forward with the facts of the case. Much obliged, Your Lordship. Your Lordship, Sabarimala is a beautiful temple that is located in between two rivers in the state of Kerala. The specialty of this temple is male devotee, they carry the mundu and with the barefoot they climb the hill and that mundu will be covered with a black cloth that shows it, they have removed all the worldly pleasures. And in this temple there is one specific restriction that is age restriction imposed on the women between the age of 10 to 50 years of women due to their menstruation and also in this case, it is also in this temple there is also another practice that women are completely prohibited to enter into the inner sanctum sanctorum of the temple. But following this restriction, a Bharat World Employees Association has filed a case before this esteemed court under Article 32 of Indian Constitution, stating that this restriction violates their fundamental principle, that is Article 14, 15 and Article 25 of Indian Constitution and also Section 3 Clause B of Kerala Temple Authorization Act 1965. Your Lordships, following the petition filed by the petitioners, the respondents have contended that there is no violation of this constitutional principles and they are protecting their customs and traditions which has been in existence for over 600 years. And also they have said that this is due to the nature of the temple, that is Naistika Brahmachari, and also due to the biological factor of the woman, that is menstruation. Your Lordships, even the apex court upheld in favor of the Bharat World Employees Association. Aggrieved by the judgment passed by this esteemed court, the petitioners has filed this review petition before this honorable court. If the bench is satisfied with the facts presented on this case, I would like to proceed with the issues involved in the instant case. Your Lordships, in this present case, there are four issues: whether this review petition filed by the petitioners is maintainable or not. Your Lordships, the learned counsel has stated that they have filed a review petition under Article 137 of Indian Constitution. But the learned counsel has failed to mention on which grounds they have filed the petition. There are three requirements to file a review petition. That is, discovery of a new evidence. And it is evident from their argument itself, there is no discovery of a new evidence and there is no important matter that has been brought before this honorable court. And also, the learned counsel has not mentioned what are the errors they have filed
in the judgment produced by this esteemed court, and there is no other sufficient reason. Rather, they have argued the same issues that has been dealt previously by this esteemed court and that has been concluded by this esteemed court by upholding the constitutional principles and also the religious practices. Your Lordship, also in the instant case, the judgment which was given by this esteemed court is valid and there is not recorded any ground for the review of the present petition. And it is not maintainable under any grounds of Supreme Court Rules 2013. If the bench is satisfied with the arguments presented on issue number 1, I would like to move forward with the issue number 2 of this case. Your Lordships, the issue number 2 in this instant case is whether the Supreme Court erred in not applying the essential religious practices test to the Sabrimala temple or not. Your Lordships, it is humbly submitted that in order to apply this essential religious practice test, the temple or the Travancore board, people who are managing the temple, as stated by the learned council, they have to satisfy 3 conditions that have been upheld by this esteemed court in their following judgments, that is Shinu Bhatt case 1954. In that case, this esteemed court has clearly mentioned in order to constitute a religious denomination, there should be a common faith. There should be a common organization designated by a unique name. In this Sabrimala temple, there is not one common religion entering into the temple. There are 3 religions they are entering into the temple. Hindu, Muslims, Christians, all 3 are allowed to perform that mandalam. And also they are entering into the temple. All these 3 religions have a different faith. They do not have a common faith. Hindu has a different faith, Muslims has a different faith, and Christians has a different faith. And also, your Lordships, just because the devotees of this Lord Ayappa or being called as a Kandi Swamis, they doesn't constitute a religious denomination as they do not have a common organization. And also, your Lordships, this Sabrimala temple do not constitute a religious denomination as it is being funded by government under Article 298 out of the Consolidated Funds of India. Therefore, your Lordships, based on the above authorities cited, it is humbly submitted that the essential religious practices test is not applicable to the Sabrimala temple, and also the Sabrimala temple do not constitute religious denomination, and it cannot claim rights under Article 26 of the Indian Constitution. And it has no authority to maintain its own internal affairs, as the Sabrimala temple is overriding the fundamental rights of the individual. The same has been upheld by this esteemed court in its previous judgment. If the bench is satisfied with the arguments presented on issue number 2 of the case, I would like to proceed with issue number 3 of this instant case. Your Lordships, the issue number 3 of this instant case is whether the court erred in characterizing the ban of women as an absolute rather than an age restriction ban. Your Lordships, the learned council has mentioned that this custom is in existence for a very long period, and they have also have a written evidence. But the written evidence has been written by the Tantris, that is under chapter 10, verses 2. The evolution of the Tantris has been happened in the year 1950, and that is also evident from the affidavit given by one of the Tantri of the temple itself in the judgment. In the previous judgment, the Tantris are originated from Andhra Pradesh. The Tantris are being appointed to the temple to maintain the purity of the sanctity of this temple. And the rules and regulations that are being followed in this temple are created due to the astrological predictions. There is no written evidence to state that this custom is in existence for over 600 years. And also under Indian Evidence Act, Section 13, which says that evidence should be in written, a custom should be in written to consider it as an evidence. And also, your Lordships, it is also important to note that in the judgment, the Lord Council has mentioned S. Mahendran was this the Secretary Travancore Board Devasam. If you look at page number, I would like to submit the judgment copy before this honorable bench. Your Lordships, if you look at page number 4, paragraph number 7 and 8, the one which I have added here. In that, it is clearly stated that before this 1991 judgment, there was a ceremony performed in this temple. That is first rice ceremony by the mothers of the child in the temple. Even in this case, the petition has been filed by the Mahendran against the chairman of Travancore Devasam Board, contending that there is a special privilege given to the granddaughter of the chairman, allowing her first rice ceremony inside the temple. Contending the allegations made by the petitioners, the chairman has given the affidavit stating that not only my granddaughter ceremony has been happened here. Before this, there are several women, they have performed first rice ceremony inside the temple. And also, your Lordship, even this temple originally belongs to King Pandara. For the same, I would like to produce the copies. And due to some conflicts in the state of Kerala, the Pandara people has flew to Tamil Nadu. And then the temple came under the control of Travancore king. When the Travancore king was in power, he used to accompanied by the Maharani to enter into the temple and offer the prayer. So it is clear that there made no restriction before 1950 or even after 1950. And the restriction has been imposed as permanent after this 1991 judgment, which is being overridden by the judgment that is passed by the 16th court. Therefore, it is evident that there is no written evidence to state it is a custom that exists in time immemorial. And also, your Lordships, I would also like to mention whether this custom is a regular practice. As I submitted the judgment before the court, it is clearly shows that there is no regular practice of this custom. To consider a custom, it should have some regularity. This custom has no regularity itself. And even if you note that paragraph number 8 of the judgment, it has been mentioned that only during 3 seasons, women are prohibited to enter into the temple. That is Mandala, Vishu, and Mahalilaka season. During these three seasons, temple used to pass a notification also stating that during this period, women are not supposed to enter into the temple. And the rest of the period, they are allowed inside the temple and to offer prayers to the Lord Ayappa. Therefore, now the restriction is imposed complete ban. That is, even during the remaining period, the women are not supposed to enter into the temple. And also, it is clear from the facts that women are not asking for the entry into the sanctum of the temple. They are asking entry inside the temple. They just want to offer their prayers being far away from the sanctum sanctorum. They are not asking to enter into the temple during their periods. And the Lord Council has mentioned why a menstruational woman shouldn't enter into the temple during the periods. And now the condition of the woman itself, it is not they are climbing for the entry into the temple during their periods. They are just asking for the entry into the temple to offer their prayers to the Lordship. That is their only motive. And and also the custom which is not in existence, then how that can be considered as a valid. So there is no validity of the custom itself. That is itself evident from the judgment which I have produced before this court. And also, your Lordships, the Lord Council has mentioned that there is a violation of Article 14, Article 15, Article 25, Clause 2, Clause B of Indian Constitution. Your Lordship, even the Article 25 and 26 also a fundamental right given to the religious denomination, and also this article 14, 15 and 25 clause B also a fundamental right given to the individuals. So the rules and regulations framed by the temple shouldn't override the fundamental rights of the temple, which was held by Justice Chandrachud in his opinion in the judgment, which is valid. And also, your lordships, a deity in the temple cannot claim a legal right, since a deity cannot be sued or can be sued, which has been held rightly by the Justice Chandrachud in his opinion. And also, there was a contention that was not mentioned by the learned counsel, but I would like to highlight here. When I read the real review petition filed in the Supreme Court, there was a contention that the court doesn't consider a judgment that is state of trading corporation. In the judgment, they have given rights to the corporation as a legal person. But here, the director is not a legal person. In the company that involves in a commercial transactions, and there happens a breach, there happen some issues. In that case, the company can be considered as a legal person, and the company can be represented through its stakeholders. But that is not seen in this present case. And therefore, your lordships, the opinion which was held by this esteemed court is valid, and there is not record for the review in this present case. And also, in the review petition, no argument should be presented. Even in few of the cases, it has been held that in review petition, there shouldn't be any oral submissions. With this, I would like to conclude that the esteemed court the judgment passed by this esteemed court has required no review and it is maintainable. Much obliged, your lordship. If the bench is satisfied with the arguments presented on issue number 3, my co-counsel would present issue number 4. Much obliged, your lordship.
The council seeking permission to proceed with issue number 4. Much obliged, your lordship. The issue number 4 is that whether the judgment caused the miscarriage of justice to the devotees of Lord Ayyappa by disregarding the Hindu religious and traditions. It is humbly submitted that the judgment did not result in a grave miscarriage of justice. Rather, it addressed the constitutional principles of fundamental equalities and the restriction prohibiting women from entering into the temple. Your lordships, it is inherently discriminates against women or solely based on their biological process, which is a clear violation of Article 14. And it also the restriction where it constitutes a form of untouchability, where our constitution clearly mentions that untouchability, which explicitly abolishes untouchability in all of its form. Your lordship, my first stance of this oral argument is harmonious interpretation of Articles 14, 15, 17, 25 and 26. The judgment able to harmoniously interpret the constitutional provisions like Article 14, 15, 17, 25 and 26 in the light of overriding principles of equality and non-discrimination. It is recognized that while the religious practices and traditions are important, they should not override the constitutional principle which is given by our constitution. Therefore, any religious practice that discriminates against women based on their gender or other any characteristics must be scrutinized in the light of constitutional principles. It is submitted that cardinal principle of interpretation of statutes is that all provisions of the constitution must be harmoniously construed. There should not be any conflict between them. Like if we see Article 14, 15, 17 on the other hand, and other hand should consist of Article 25 and 26. There should not be any conflict between them. They should be harmoniously interpreted. So, based on Constitution, Article 26 enables not enable the state to make any law which discriminates the women, or it has to, nor it does not protect any custom which discriminates against women. Where in page number 38 of the memorial of 5-inch judge of this honorable court, in the case of Venkatamana Devaru and others versus state of Mysore, which is a famous case, while acknowledging the right to restrict entry of Gauda Saraswati Brahmins, the Supreme Court has rightly held that it is subject to the Madras Temple Authorizer Act, where in any event Article 26 does not permit any discrimination between a class of Hindus based on their sex.
It is submitted that in any event, right to worship for Hindu women has been abolished between the ages of 10 to 15, where there is a restriction of the right to practice religion guaranteed under Article 25. Next, the second stance of my argument is international norms and convention. Your Lordships, India is a party to the international conventions and treaties, such as Convention on Elimination of All Forms of Discrimination Against Women, which is known as CEDAW. CEDAW mandates the state parties to overcome, dismantle anything promoting gender stereotypes. There is a stigma created around menstruating women where they are not entered into the temples. This should be this is the contrast with CEDAW, where the Committee of Elimination of Discrimination Against Women has explained the state parties to modify and transform where there exist harmful gender stereotypes or eliminate where there is wrongful gender stereotypes. The General Comment number 25, CEDAW Committee stated the obligation that CEDAW imposes the state parties to make following goals. Firstly, it should ensure that there is no direct and indirect discrimination against women. Secondly, the state parties have to improve the policies and programs which will eradicate this stereotype. And thirdly, the state parties have to go through the individual acts, not only individual acts by individuals, but also the legal, societal instruments and institutions. Where if we see in Article 5 Clause A of CEDAW, where the Convention has clearly mandates the state to modify and the cultural and social patterns of conduct of men and women in roles of gender stereotypes, where there is based on inferiority and superiority rules, where there is a gender stereotyped things. All these should be eradicated by the state parties. And Article 10 of CEDAW ensure on a basis of equality, men and women, the elimination of any stereotyped concept of men and women should be eradicated in all forms of education by encouraging co-education and other types of education which will achieve this aim, and also in particular by division of textbooks, by school programs and adaptation of teaching methods. It is submitted that in paragraph 14 of Visakhapatnam versus State of Rajasthan in page number 39, where it is a famous case of sexual harassment of women in workplace. It is clearly stated by the Supreme Court itself, the rule of judicial constitution which requires the international convention must be followed. When there is war in the domestic law or when there is inconsistency with the domestic law, the international convention should be adopted by the parties. It is submitted that the state parties have a due diligence obligation to take all necessary steps to enable every person to enjoy their right. It is submitted that both constitutional and international obligations mandate the state to eradicate the problems relating to menstruating women based on the customs and tradition, and the women should not be portrayed as objects of temptation that need to be kept away from brahmacharis. Therefore, the judgment also upheld India's international commitments to gender equality and also such as Convention on Elimination of All Forms of Discrimination Against Women. Therefore, Your Lordships, the judgment did not cause any miscarriage of justice to the devotees of Lord Ayyappa. Rather, it addressed the fundamental equalities and it also harmoniously interpreted the constitutional provisions and it also upheld the international commitments. Therefore, contributed to the advance of constitutional values and the protection of fundamental rights of all individuals, including women. If the bench is satisfied with issue number 4, I would like to go with the prayer. Wherefore, in the light of arguments advanced and the authorities cited, the respondents humbly submitted the honorable bench may be pleased to adjudge and dismiss the review petition filed by the Dravidian Board, where there is no material error in the pre-judgment passed by the esteemed court, and also upheld the judgment as the judgment rightly struck down the age-based restriction on women entry to the Chakra and directed the Dravidian Board to implement the judgment in its entirety. This includes ensuring unimpeded and dignified entry of women to all ages, and
any other order as it deems fit in the interest of justice, equity, and good conscience, and upholding the principles of equality and religious freedoms of all citizens of India. Much obliged, Your Lordship. The respondents feel much obliged to present this case before the bench. Much obliged, Your Lordship.
Okay, first of all, my question is for petitioner's side. You reported that Article 14, equals should be treated equally and unequal should not be treated equally. So how can you justify this comment with regard to your case? Actually, this is the issue of women. That is, I don't want to explain about that, but you have cited this for this case, okay? So how can you justify those comments in support of your case?
Because, Your Lordship, even though if women is treated as a class, there should be no differentiation based on the class, Your Lordship. There can be a limited restriction which can be opposed, and also, Your Lordship, women, not only on the all ages of women is restricted, Your Lordship, there is a limited restriction on a valid basis. Hence, it can be treated as a exception under the doctrine of reasonable classification, Your Lordship.
I mean, your respondents have mentioned certain facts, how that Akshara Pitam. First feeding, first rise, okay? So there are instances that certain people have been allowed then how can you justify that classification, class of individuals, where the mothers will accompany with the younger children?
Because, Your Lordship, mothers are differentiated from the other menstruating women, Your Lordship. And also here, I would like to put up a point that how
Nature of people, I think there is no such classification. Okay? You are actually good, but I think it may not be suitable for this situation that classification of individuals based on their.
So mother accompanying child and another woman. You mean to say there is a classification?
it's not, the judge, if you don't mind, can I come to the podium?
Yes, please come. You have to come to podium.
First off, I'd like to submit some compendium on behalf of the petitioner, Your Lordship.
Resume the.
And
Resume the.
coming to the point, Your Lordship, since the mother belongs to a woman of another man, in the eyes of the Lord, he cannot be treated her as a restriction. So that is why there has been a limited restriction to the first right of the mother inside the temple, Your Lordship. And also, I'd like to put up a point here, Lordship. How many women of menstruating women are going into the other temples during their menstruating time or menstruating period? Because there is no real.
Actually, this is not the case of during the menstruation, but it is the case of menstruation age. Okay. During menstruation, no women are there to go. Okay. That is our custom, and we have to give priority and importance. We respect. Okay.
Indeed, Your
But
Lordship.
here, age, menstruating age.
Because the celibacy nature, permanent celibacy nature of the Lord Sasta.
You are telling that we have to respect what Ayappa God.
Indeed, Your Lordship. And also, sometimes the law is unlawful, Your Lordship. Okay, even though the Supreme Court has given the verdict as they lift the ban on the entry of women. They have said that women of menstruating age can we go inside the temple. Since the verdict came out, how many menstruating women actually went inside the temple? A couple of two. Why many other women haven't been entered into the temple? Because
How many grandmothers were working in 1920s or 1860s? How many grandmothers were working in 1860s or 1920s or 1950s? How many? So time is changing, okay? According to the changing circumstances at times, we have to adopt.
indeed, Your Lordship, in the same
No, this is the opinion of Supreme Court, not mine, okay?
In the same way, we have to respect the God too, Your Lordship. Even though the Supreme Court has already given the verdict, but in the respect of the God's name, many other women didn't even dare to enter into the temple because of the true divinity. If a person who is having a true divinity would never ever go on the opposite side of the God and would never violate his interests and rights, which needed to be protected. It should not be seen only on the gender equality. It should also be seen on the traditional side, and we have to value on the Hindu religions and customs. If not, the original Hindu religions might be gone away.
Okay, I agree with that. But it should be purely out of their own interest. But the temple doors shall be open for everybody. That is the concept of Supreme Court judgment. Okay? If you are truly religious person, then you will respect. Okay? But you have to treat all the people. Otherwise, again you will be confined to teachers only. That is women. That is the opinion expressed by Supreme Court of India, and that's why we have used that pollution. Okay? Okay. Anyhow, your argument is very good and fine.
And also,
Finally
there is
decided.
another point I'd like to put up, Your Lordship. The opposing counsel has been said that really the temple is for all, even Hindus, Muslims, Christians, anybody of any religion can be entered inside the temple, since it wouldn't make a religious denomination. So here, even though a person of any religion enters inside the temple, they'll be thinking that the beliefs and the faith will only be put up on the Lord's Sasta. A Muslim man cannot enter into the temple and be praying for Islam or praying for Allah. Same as a Christian cannot go inside the temple and pray for Christ. Here, even though the religion is different, their faith and towards the God is same, Your Lordship.
Okay, what is what I can say? Can we see what he is praying, a Muslim man or Christian man in the temple by wearing these masks, etc.?
Your Lordship, it is so obvious that if he would have prayed to Islam, he would have done inside his house or anywhere else. Why he wanted to come to the temple and pray for Allah or other religious gods, Your Lordship? Because the thinking would be the same. If I wanted to go voluntarily, if I wanted to go inside a church, I'll surely be praying to the Lord Christ only, Your Lordship, not to any other religious gods. If I voluntarily go inside a temple, I'll be praying only to that temple religious god, Your Lordship, and not more other than that.
Okay, your defense is good, but the contrasting facts are there. I mean, in 1950s or before 1950s, women, they were used to go and come to that temple. Okay? Opponent has shown those evidences.
The Tantric Samuchara text is written in 1428, Your Lordship, which is very old, and it is not written in the year of 1950, Your Lordship. It has been prevailing from the time immemorial.
Actually, this commissioner herself has witnessed before the Supreme Court, Chandrika. Okay, there were instances where people, women will come and visit the temple. We cannot deny those facts with our arguments. Okay?
There are instances where menstruating women have come now and then from before the time, Your Lordship. They have maintained a rule because that entrance of the women shouldn't eradicate the energy of the Lord's Supper, because if a menstruating woman has entered into the temple, it might disrupt the energy of the Lord's Supper. So after entrances of experiencing the entrances of few menstruating women inside the temple, they have come with the rules and regulations to restrict limited restrictions of the age factor.
Okay, that's why I am telling. Your defense is good, but you cannot change the fact.
Indeed, Your
Okay,
Lordship.
good, ma'am, good.
Much obliged.
There is a classification like you I want to know. Absolute restriction for a limited period and the partial restriction for a limited period. This law, see, during the menstrual period, the restriction can be there, right? Because no woman will go during the menstrual period. But why this age restriction is imposed from 10 years to 50 years? Instead of that, they can as well say that during menstrual period, woman is not allowed. That should have been the best way.
Because on that point, Your Lordship, this age restrictions has been imposed because it would affect the celibacy nature of the Lord's Astavu, because they have the capacity to reproduce. That is the fact, Your Lordship. The women of the 5 to 6 days on her periods cannot be accustomed to produce. They cannot be the capacity to reproduce. On the other side,
See, the result is, see, here, absolute restriction. From 10 years to 50 years, absolute restriction.
that is what
That is not violative of Article 14.
Your Lordship, because they tend to have.
If it is like this, means it is okay. During menstrual periods, no one is allowed to enter into temple. That restriction can be accepted. But whereas, total restriction from 10 years to 50 years, no woman is allowed to enter.
Actually,
It
the
is not violative of Article 14.
Your Lordship, actually the fact is, women on her periods doesn't have the capacity to reproduce.
No, forget about all these things.
That is the point, Your
Forget about
Lordship.
reproduction, forget about it. during menstrual period, there can be a restriction.
Because the other women of menstruating age women, they have the capacity to reproduce.
That is okay.
That is the main factor on the side of Lord Sastavu. It might have effect his celibacy nature. Being a Naistika Brahmacharya, because he took the Naistika Brahmacharya, he should not come into contact with the women who is capable of reproduction. That is why the age restriction is, your lordship, and not only period basis for 5 to 6 days, your lordship. That is the reason, your lordship.
Do you have any evidence to show that the reproductive system will be affected if they are allowed between 10 years to 50 years?
Actually, the Sabarimala temple has constructed on a 6 chakra basis, your lordship. If a menstruating woman would enter into our temple, which is constructed under the 6 chakra based on the Agamas text, it would affect the woman's Mooladhara chakra, which is situated around her uterus, thus affecting her menstruating period, your lordship.
Considering the chakras itself.
Because
Chakras itself I am questioning. Do these chakras have a scientific basis?
yoga basis, your lordship. On the basis of yogic science, yoga is the science, your lordship, which is known as yogic science. And the chakras belong.
Pure science is better than yoga science, no?
Your lordship, actually we have to respect the yogic science
Scientifically.
because it is began in India, which has spread all over the country, which is it has the yoga science has been respecting on the western side so much. While here we are questioning about the yogic science and the capacity of the yogic science holds, your lordship.
Do you have any evidence to connect these chakras with the scientific evidence?
Obviously, the chakras, there is in the compendium, there is the
Okay, okay.
yes, your lordship.
You have to defend.
For example, since the chakra
Scientifically proven that the aura, generated through the chakras, that will affect. That you have to define with the.
in this, your lordship, in this point, I would like to give an example. So, in order to prove a chakra to be effective, to be a real, I'd like to talk about few yogic poses. For example, there are lots of yogic poses, and also there is an actress called
Shiva is telling not to defend with yoga and to defend with pure science. Then you can take the physical sciences which will affect the, the aura that is there, the light effect. That you can take into consideration to prove it scientifically, right?
Indeed, your lordship. Actually, the architecture is built on the scientific terms, your lordship. The architecture of the Sabarimala temple builds on the scientific terms.
So the physics also proved that.
And indeed, your lordship, indeed. So regarding the temple is built on the scientific basis, it can affect the health on the women, and also it can affect the chakras of the women. And if I wanted to prove that how chakras is effective, if I wanted to prove that factor, the remaining asanas, the remaining many asanas in yoga which are very efficient, and many actors now have been following the yogic technique to stay alive. But the most relevant example for this is actress Shilpa Shetty. She herself contended that only basis on the yoga. I have been saying this young till date. Till date, she has been seen so young, your lordship. Because yoga is not only about the tradition, it is about the science as well, your lordship.
You have to follow yoga or not?
Yoga,
Physical activity, we can support it, but chakras invisible. Okay.
yogic science and the law comes in hand, your lordship. Since yogic science is based on the customary rights, which is subject to religion, which is
your lordship. Yeah, yes, sir.
Say above 10 years, below 50 years. If a girl gets menstruation below 10 years, or if a woman goes on menstruating after 50 years, whether such a woman are eligible to enter into the sanctorium of the temple.
On that point, your lordship, laws, anytime when a law or a rule has been made, they make that law in the perspective to benefit the maximize percentage and not, they never be 100%, your lordship. They can be a 95%. So since the many women have get their menstruation during the age of 10 to 50 on the maximizes basis, on the maximum percentage, they have made this rule.
So you want to say that if a girl menstruates below 10 years, and if a woman is continuing the menstruation of 50, they can go into the temple.
No, your lordship.
That's what I am telling. You are telling 10 to 50. So below 9 years and above 50 years, they can enter to the temple.
There have been some exceptions to that, your lordship.
Is expected like the definition of major. Only when a person
Another thing.
is 18 years,
Sir,
it becomes a
you
major.
cannot say. Obviously, you cannot say. Another thing is, have you gone through story of that god Ayyappa?
Yes, your
Have
lordship.
you gone?
Yes, your lordship.
He moved with tribal girl.
Malika.
Malika or something.
Malika.
He goes to the extent of protecting her from the Yama, from the clutches of Yama. And another girl who suffers with this mental disorder. He saves her. He moves with this discarded woman, who are vulnerable discarded woman. I have gone through the total history until he incarnates as God. He moves with only one woman, he saves woman. This disqualified woman. Now, how can you say he don't want to allow into the sanctum that is qualified, that woman? Sanctum.
On that,
He moves during his whole time with woman. Mother కావచ్చు, కొంతమంది affected woman కావచ్చు, girls, he saves them. Now, what is the logic? What is the rationale behind keeping this? By taking into his account his history until he incarnates as God, I don't digest the rationale of disallowing the woman between 10 and 50 years.
on that
He was
point,
moving with all women. He saved several women in his life.
on that point, your lordship, Lord Sastau is not a celibate from the beginning of his birth, your lordship, until he attains a particular age. After that, he took a permanent celibacy, your lordship. And also, it's not his complete form. He has been as a kid, as a young man, and also a married man in the Achan Kovil Dharmasastha temple, your lordship. It is just a form of Ayyappa, your lordship.
So you want to say that you are questioning the celibacy of the God itself. By putting these restrictions, you are questioning the celibacy of God himself.
Why would I question the celibacy of the Lord, your lordship? I've been supporting the celibacy nature of the God, of the Lord Sastau in a particular form.
No? Since if the woman between 10 and 15 years goes to that God, he may change his attitude laga undi, a restriction.
In that particular form of the deity, as Sabarimala Ayyappan deity, he has took a of the all.
All right, I will take. Just morning, I will just shave my face. Same with woman. Menstruation is a common thing to any woman. So that cannot be a disqualification. As then the shaving of men also must be prohibited.
Because menstruating women are different from shaving the beard, Your Lordship.
How can we differentiate?
Menstruating women
How stand on the same footing?
they have the capacity to reproduction, and shaving the beard and shaving the head doesn't change anything biologically.
Same with women, those 3 days, 4 days, once again they will resume their.
But they have the reproduction system in their body, which is a biological process.
Reproduction system, yeah, that is the origin of universe.
Indeed, Your Lordship, indeed. Which the example which you are being referring to shaving the beard.
Universe will not survive.
On that point, Your Lordship, which the example you have been referring to a shaving of a beard, it doesn't change biologically anything, Your Lordship. But here, before the age of 10 and after the age of 50, the menstruation capacity in the women as a biological practice process has been changed here, Your Lordship. We cannot compare something which is unchangeable and which is having a change biologically, Your Lordship. It cannot be compared.
I'm not satisfied with your explanation.
Much obliged. Much obliged.
You have presented a case, but not satisfied.
So Ayyappan Swami moved with woman.
Before is
What I say? Ayyappan Swami moved with woman. But at the same time, he put the restrictions of woman not to enter, not to break. But what purpose? Ayyappan Swami moved with woman?
To protect itself, Your Lordship. When the Lord of Tao is moving with women, he will be in another form, which is not considered as a secondary.
So you want to curse the woman between 10 and 15 years, 50 years. God wants to curse the woman between 10 and 15 years without giving consent to them.
Is that reasonable restriction?
It is not a curse, Your Lordship. It is a limited restriction on the state of the
I
particular.
say that you are cursing that woman.
No, Your Lordship. If a woman wanted to pray to Lord of Tao,
I go to the temple. I feel it's a privilege. I feel relaxed after coming out of the temple. Still, you are not giving consent to those women between 10 and 15 years under the guise of some disqualification, personal disqualification. You are cursing them.
Your Lordship, it is not a cursing, Your Lordship. It is a stage of life. Even we have to respect the perspective of the God.
I say, I definitely believe and I confirm that in the name of restricting that woman between 10 and 50 years, you are cursing them. But,
Your Lordship, if a woman below 10 years and above 50 years would wanted to go inside the temple out of the all odds, out of the violation of the all the rights from the perspective of the God, she herself isn't considered as a true devotee, except Your Lordship. As a true devotee, someone never do.
nobody needs to go to the temple. You can see the God within yourself. Then I need not go to the temple. I too visited the temple 3 or 4 times. I stayed there for 3 days. Morning to evening I was there during August period. Peak, very weak period. If you say that by restricting those women, you can see the God within yourself. Then nobody had no necessity to go to the temple. You can see the God within
Your
yourself.
Lordship, it is not only about the restriction of a woman of a particular age, and also men of a pregnant woman is not supposed to enter into the temple. It is because the gender is of menstruating women. Even on the men of a pregnant woman is not supposed to enter. It is the ethics and the religion, tradition, customs of the Hindu of the particular temple authority, Your Lordship. It is nothing to do with the menstruating women.
You can say it is strong traditions which are beyond the judicial pronouncements. Strong traditions like Tamil Nadu, Jallikattu, Kurnool, Malakonda Swami, Andhra, Kottapadam, ఇవన్నీ beyond judicial pronouncements. They are not reached. That's the Sriharikota, all are experts. Sriharikota, all are scientists. Before leaving that satellite, they will go to Chakra temple. So, it's beyond certain things. Instead of arguing, those traditions are beyond certain things. We cannot respect it. Slowly they have to be removed.
It's a pleasure.
Respondent. You see, there is a conflict between fundamental rights and religious rights.
Your Lordships, as I mentioned before in my argument, there is no validity of the custom itself in the temple. Because as one of the Lordships has mentioned about the tribal women, there is one of the interview given by a person who belongs to tribal family from the Kerala, who has said the management of the temple itself under the Malay tribe control. And for the same, I would like to submit one of the evidence document before the court. That was the interview conducted with that Malay tribe itself. And that is also one of the controversial issue at the present day also. There has been a controversy between Devasa Board people and also this Malay tribe people. The Malay tribe people were following different set of rules and regulations in the temple. They were performing this Stay Abhishekam. Now the Tantric has come and changed it to Nai Abhishekam. So there has been controversy between the history of this temple itself, because there is no evident written document to state this custom is valid for this period of time, because there has been changes of rules and regulations by set of people. And for the same, I would like to produce the interview document that is conducted from one of the Malay tribe people. Hence, Your Lordship, there is no validity of the custom itself. There is no regularity of the custom. This custom.
Another thing I want to say, Ayyappa, not only Ayyappa, there were 600, 700 years. Sai Baba, Shirdi Sai Baba, 1917 or 18, he went away from the world. Until his death, he lived a very simple life. He never looked after his food or clothes or anything, cleanliness, everything. Only after his death or something, the people began to statues and kiridam, button, golden rastu, all this. Same with Asinayana, so Gannavada. You drink something Nilur. Venkaya Swami, just 50-60 years back, like, he lived a simple life. Cigarette, waiting all the bus stand. Now, step one is developed like he is being incarnated as a princely king, princely deity. Like this, all these traditions, whether it is Sai Baba or the latest Venkaya Swami or Asinayana or earlier Yamma Swami, these traditions are only manipulated to elevate the God to a particular stage. That's what we can say.
Indeed, your lordship, even likewise, how this God has different rituals and customs. Even in the Hindu Dharma, we do not follow only one specific Shastra, that is, we follow Vedas, Manusmriti, we also follow Agama Shastra. The same menstruation is called as impure in Manusmriti, and the same menstruation is called as sacred, and she is known as goddess in Vedas. Therefore, it cannot be contended that this menstruation and also the age-specific restriction as a valid custom of this temple, since there is no written evidence.
Okay, thank you for the tips.
Much obliged, your
Our work itself is pure. The very work.
Indeed, your lordship.
So we are not eligible to go to the God. Either woman, they are not eligible to go to the God.
Indeed, your lordship.
Thank you for both the teams. I will wait for a few minutes. The mark of respect will instead of judges who have come from different places. And also, prize distribution after your selections. Right? I will wait for 15 minutes, the entire proceedings will be completed. Thank you.
Students, I congratulate all the teams. You have performed excellently, and your performance is excellent. Okay? Each and every contestant, okay, participant. Keep it up. Thank you. All the best for your future endeavors.
Face what we do.
Sorry. violence, 3 hours, 103 hours again. Only say reason.
यहाँ projects बड़ा बनाएगा तो address you make the importance of
I know pretty well that you are not in a position to hear what I say. Because it is time for food already 3. It's already 3 p.m. What the moot courts are useful, how the moot courts are useful for budding advocates is, now you will prepare the skill of debating. In the court, you will be cross-examining, you have to prepare the pleadings, counter pleadings, examination, cross-examination, and finally argument. Isn't it? Now, it is a stage for you to rehearsal how to prepare the cases by way of plain or written statement, how to cross-examine the witness. Now, chief examiner has gone. Now we will be preparing the chief examination affidavit. How to cross-examine an adversary, witness or client, and how to argue the case legally. And to bring the case to a logical conclusion. Here also, it is a preparation for you, as a student of law. How the case is to be prepared, plain is to be prepared, written statement is to be prepared, how to cross-examine the witness, well, case, your client's case. So it's a logical conclusion. Then coming to the subject. Recently, while I was going to the subject, Manuvada came to an end with Maurya, age of Chandragupta or Ashoka, I think so. Until then, what the Manuvada people were adopting in the country, they will be doing homos, killing layered students and throwing it in the homos. The best parts out of it they use it to enjoy. The worst part they use it to go to Godra. That was the thing which was going on with the invention of Jainism and Buddhism. You know pretty well the principles of Jainism and Buddhism is ahimsa parama dharma. సత్యాలే చెప్పాలి. అహింస అంటే జీవహింస ఉండకూడదు, సత్యాన్ని చెప్పాలి. These two are the main principles in the Jainism. Ashoka and Chandragupta after history is after Ashoka and Chandragupta, nearly 10 people of their coming after these people ruled the country. When Jainism and Buddhism went to the peak stage, lastly, when the 10th king was a weak one, a Brahmin Devadipati was there with him. He killed the king once again. This Hinduism, Manuvada came once again to the picture. They changed the Buddhist Jain people. They killed them. All of them migrated to other countries like Simala, that is Babo, Nepal, like this. That is why, though Buddhism was born in our country, it could not survive. So now, whether it is Ayyappa, Tantric, or Sabarimala, this Siddhi, Sai Baba devotees, main devotees, or any god, they will be evolving their own way of puja or ritual. They will get deep into the society which cannot be so easily wiped out. As time passes on, education improves, knowledge improves, slowly these things will go. Just because the Supreme Court decision is there, we cannot expect that traditions or the concrete ideas will go. And even after the Supreme Court decision is over, decision is given, the ladies are unable to go to the temple. Say several restrictions were placed at Kurnool temple, but that beating and death of devotees is not going on. Civilization and culture both are improving. These traditions will slowly go out. Courts cannot sit and pass orders in that until it comes to a stage of maturity when it becomes irrelevant. The traditions automatically becomes irrelevant. You take the case of Tamil Nadu, Jallikattu, though it was prohibited by Supreme Court judgment, they have passed another better enactment. They are continuing. So I to come when these traditions or these rituals, meaningless rituals, have to go out. So we have to go on discussing like it. Stage will come when things will come. Thank you.
Respected retired judge, Purapanayan sir, and beloved Global Law Institute correspondent sir, and different sir,
my dear colleague, Madam, and Principal of American Global Institute. Sir, my student, Nancy, and other guests. Very good afternoon. I need just to engage 1 minute, okay? No worry. So, dear students, really, your preparations are very good. I can imagine how much hard work you have done in preparation of this Moot course. Thank you, Vanada, for giving us this opportunity here. And myself, Dr. Tantric, working assistant in the Department of Technology Management. And my student, your teacher, Dr. Asmi is also here. And her mother is my sister, and I am very happy to be here. Just one line I want to say. In preparation of your Moot course, you are a team, okay? I think you might know that, but I want to give a small suggestion how to engage the third person. She is ideal, okay? That boy is ideal. You are presented, you both have presented, but these two are, no work, okay? On the stage, okay? So, you are submitting that is, okay, to the judges. That's what can be assigned to these people. Usually that will happen, okay? When you want to present the evidence to judges, then you should ask that boy, submit the evidence to judges. That you can do. I don't know whether you will follow or not, but it's a, formality, okay? The third one shall be given to them. And for her assistance in preparation of material also, the prizes, etc. will be given. Okay? But I want to congratulate Department sir for organizing and conducting this huge Moot court competition, and your principal sir and your other it's a great initiative, and you should be very thankful and grateful to your correspondent sir for bearing all these expenses as well as time. Thank you one and all. Thank you very much for giving us this. I want to tell you openly one thing. I am a student of this American Global Law Institute. Back to 1997.
Now this is a time to announce the results. Moot court results. The best memo is 502. The best memo ये अनुजा यम मगीदा so best memo is prize for village. Next. The best speaker Mr. CVS Sharma. Then runner-up team. Yeah. 103. Course number 103. Runner-up. The team names are A. Himani, M. Maheshwari, D. Anusha. Right? I hope I did not tell you anything. Already over. So the winning team is 102. And the winning team are K.S. Charishma, A. Tanuja, M. Mahila.
So now it's the time to give the prizes. So I would like to call the best memorial team, team 102, to the dais. A. Tanuja, BA LLB, M. Mahida, BA LLB. So next, best speaker award, CVSS Sharma, BA. That side, because here camera, that side. Mahida.